Okay, I think we can start now. We're already given them enough time. Okay, so our topic for today will be auction. First will be auction sale. So it's still related to sales, but let's look at auction sale. So it's a public sale in which goods or property which are sold to the highest bidder. Okay, so the rules of auction sales would be that sales of separate lots by auction are separate sales. So where separate lots are subject of separate biddings and are separately knocked down, there is a separate contract in regard to each lot. Okay, so sale is perfected by the fall of the hammer. In putting up the goods for sale, the seller is merely making an invitation to those present to make offers, which they do by making bids. Okay, so it's an offer, kaya invitation. Okay, and then they will have their um, the buyers. Okay, will make their offers. Okay, or the prospective buyers will make their offers. Pending announcement, any bidder may retract his bid, and auctioneer may withdraw the goods unless auction without is reserved. Okay? So, as long as hindi pa siya na final, hindi pa nagtunog yung gable, 'di ba? Na sold, ibig sabihin pwede ka pang umatras sa pagbid. Okay? Or the auctioneer may still withdraw the goods. Okay. So, the right of seller to bid in the auction. Okay, the seller or his agent may bid in an auction sale, provided where no notice given of right to bid. So, where there is no notice that the sale is subject to seller's right to bid, it shall be unlawful for the seller to bid either directly or indirectly, or for the auctioneer to employ or induce any person to bid on behalf of the seller. Okay, so by bidders or puffers, persons employed by auctioneer who will bid without being bound but whose bids will have a tendency to induce or provoke higher bids from interested buyers, thus misleading the latter because of the inflated bid price. So, kaya siya unlawful kasi it drives the price higher or the bid higher, no? So, well, in some cases, really, it could happen, but it is illegal. It's unlawful, okay, because it will induce, meaning it will mislead as well the prospective buyer the price, no, because he will be compelled, or at least somehow will feel compelled to bid higher just to win the auction sale or the bid, but um, those other bidders are not bound by their bids, meaning they will not be held liable for whatever they bid in the price in bidding. Okay, so these are buy bidders or puffers. It is the secrecy of the putting and not the authorized bidding by the seller which makes it fraudulent. Okay? Where notice of right to bid is given, though bidding by the seller or his agent is fraudulent, a right to bid may be expressly reserved by or on behalf of the seller. So, where there is notice of the intention to bid by the seller, the bidding in such a case would not operate as a fraud because it has been properly disclosed to the bidders that the seller will also bid. Okay. So, as a prospective bidder, you should be conscious of bidding, okay, competing with the price because you know that the seller is also bidding. Okay. So, contract not to bid. A sale may be fraudulent not only because of conduct of the seller but because of conduct of the buyer. It is not permissible for intending buyers at auction or other competitive sales to make an agreement for a consideration that only one of them shall bid in order that the property may be knocked down at a low price. Hindi rin pwedeng ganon, okay? Hindi rin pwedeng luto na ang bidding, no? So you cannot agree among yourselves, okay? Advertisements for bidders, they are simply invitations to make proposals, and the advertiser is not bound to accept the highest or lowest bidder unless the contrary appears. So the advertiser, the auctioneer also still has, or the advertiser has still the right to choose among the bidders. Okay. So what are the rights of the owner to prescribe terms of public auction? The owner of the property which is offered for sale either at public or private auction has the right to prescribe the manner, conditions, and terms of such sale. He may provide that all of the purchase price or any portion thereof should be paid at the time of the sale, or that time will be given for that payment, or that any or all bids may be rejected. So the conditions of a public sale announced by an auctioneer or by the owner of the property at the time and the place of the sale are binding upon all bidders, whether they knew of such conditions or not. Okay, if you want to read the case, that's in the case of Lukinko versus Postal Savings Bank. Okay, also have the ownership of the thing transferred by delivery. So the delivery of the thing sold is essential in a contract of sale. Without it, the buyer may not enjoy the thing sold to him. After the delivery of the thing sold, that the buyer acquires a real right or ownership over it. Delivery may be actual or constructive. Okay. What's the exception to this rule? The parties may stipulate that despite the delivery, the ownership of the thing shall remain with the seller until the purchaser has fully paid the price. So, in this case, there is no transfer of ownership. But by default, upon the delivery of the thing sold, okay, what essentially happens is there is a real right or ownership over the delivery sold and bought by the buyer. Sold by the seller or bought by the buyer, okay? And the delivery may be actual or constructive. Actual, by actually delivering in physical the item or the property, or like handing in the keys, okay? Could be constructive delivery, okay? Kinds of promise treated in Article 1479. So these are, okay, it applies specifically to a promise to buy or to sell. It refers to three kinds of promise, namely, an accepted unilateral promise to sell in which the promisee or acceptor elects to buy, an accepted unilateral promise to buy in which the promisee or acceptor elects to sell, and a bilateral promise to buy and sell reciprocally accepted in which either of the parties chooses to exact fulfillment. Okay, so what are the effects of an accepted unilateral promise? A unilateral promise or offer to sell or to buy a thing which is not accepted creates no juridical effect or legal bond. Okay, such an accepted offer is called policitation. Okay, option is a privilege existing in one person for which he has paid or a consideration which gives him the right to buy or sell. So if it's a unilateral promise, okay, unaccepted unilateral promise, it does not bind anyone or it does not have a juridical effect or legal bond. Kasi unaccepted naman siya eh. It's a unilateral promise. Okay. But there is this called option. It is a privilege existing in one person for which he has paid a consideration which gives him the right to buy or to sell. So you are actually paying so that you will be given the right to buy or to sell. You can you can choose not to push through with buying or selling, but you reserve the right. Okay, that is an option. Okay. By the way, before I forget, did I just put here? Attendance. Okay. Okay. So I've put the attendance link in the chat box, ha. So just beware that you'll have to fill it out. Okay, so the effect of accepted unilateral promise, uh, a unilateral promise to sell or buy a determinate thing for a price certain does not bind the promisor even if accepted and may be withdrawn at any time. The effect of bilateral promise to buy and sell. When a promise is bilateral, one party accepts the other's promise to buy and the former's promise to sell a determinate thing for a certain price, determinate thing for a certain price. The concurrence of both acts, the offer and the acceptance, generates a binding contract of sale. Okay, it's bilateral. Rise of loss or deterioration. If the thing is lost before perfection, the seller bears the loss. Again, if the thing is lost before perfection, the seller bears the loss. If the thing is lost at the time of perfection, the contract is void or inexistent. The legal effect is the same as when the object is lost before the perfection of the contract of sale. There is nothing to sell in this case. If the thing is lost after perfection, before its delivery, even before the ownership is transferred to the buyer, the risk of loss is shifted to the buyer as an exception to the rule of res perit domino. If the thing is lost after delivery, the buyer bears the risk of loss following the general rule of res perit domino. Okay? So, scope of Article 1480, the first applies to non-fungible goods. The risk of things sold passes to the buyer even though the thing has not yet been delivered. Okay. Applies to non-fungible goods. The risk of the thing sold passes to the buyer even though the thing has not yet been delivered to him. In other words, the buyer assumes the risk of loss caused by fortuitous event without the fault of the seller. The second rule relates to fungible things. The vendee assumes the risk if he has incurred in delay in receiving the goods. Okay. So, meaning if the goods is lost, okay, if non-fungible goods is lost due to fortuitous event, then the seller, okay, I mean the buyer assumes the loss, bears the loss after the sale, okay. In the second rule, it relates to fungible things, where the vendee assumes the risk if he has incurred in delay in receiving the goods sold. Vendee or the buyer, okay. The buyer incurred delay in receiving the goods and the goods were lost, then he bears the loss. So the sale of goods by description and or sample. The term books, a bulk of goods, does not designate the greater portion of the goods. It denotes the goods themselves as distinguished from the sample and or description with which they must correspond. Sale by description, where a seller sells things as being of a particular kind, where the purchaser has not seen the article sold and relies on the description given to him by the contract may be rescinded. Okay. Sale by sample. In a sale by sample, the seller warrants the thing sold to be delivered by him shall confirm with the sample in kind, character, and quality. There's also that sale of by description and sample. When a sale is made both by sample and by description, the goods must satisfy all the warranties appropriate to either the kind of sale, and it is not sufficient that the bulk of goods correspond with the sample if they do not correspond with the description and vice versa. Okay, so tatlo to ha, sale by description, yung bigyan mo lang siya ng common to, even right now, online, no? Sample, ano yung specs niyan? Diba? Bigyan ka lang ng specs, description, ganito siya o itsura. Where the purchaser has not seen the article sold and relies on the description given him by the and the contract may be rescinded. Okay? Sale by sample, yung may papakita kang sample. Okay? Which will confirm in kind, character, and quality. Sale by description and sample, both description and the sample actually is given to the buyer or prospective buyer. What about earnest money? Earnest money is given by the buyer to the seller to bind the bargain. It is actually a partial payment of the purchase price and is considered as a proof of the perfection of the contract. Advance payment, it must be deducted from the total price. So, in other words, if there is earnest money, it confirms the perfection of the contract. There is already an existing contract of sale. And and it's just awaiting the full payment of the total contract price or the total amount of the sale. But in this case, the sale is already perfected. That is earnest money. This is different from option money because option money is just a consideration for the option for you to purchase, while earnest is already a purchase price you have given. Okay? Earnest money is given only where there is already a sale. Okay? Option money applies to a sale not yet perfected. When an earnest money is given, the buyer is bound to pay the balance. While when the would-be buyer gives option money, he is not required to buy. Okay? Sinasabi lang niya, I have the option to buy, so I reserve my right to choose to buy. But I am not bound to be compelled to buy. Okay? But option money may become earnest money if the parties so agree. So kung option money, nag-agree naman yung parties that it will become an earnest money once they have agreed that the buyer will actually go to buy, then that is going to be an earnest money. But it does not necessarily mean that option money is the same as earnest money. Earnest money, there is already a contract of sale. Option money, there is no contract of sale yet. There is, however, an option given to the would-be buyer, okay, to purchase. Okay. So again, earnest money, it is part of the purchase price, while option money, it is given as a direct consideration for an option contract which gives the buyer a specific period within which to purchase the thing. Earnest money is given only when there is already perfected sale, while option money, it is given at a time when the sale had not yet been perfected, and what had been perfected only is the option contract. Okay. Earnest money, when it is given, the buyer is bound to pay the balance of the agreed purchase price, while the option money, even if the option money is paid by the would-be buyer, is not bound to buy the thing. If the sale does not materialize, the earnest money paid must be returned unless a contrary agreement had been stipulated. While in option money, if the buyer decides not to buy the thing, he cannot recover the option money he paid as a consideration for the contract option. Okay? So what are the forms of a contract of sale? General rule, a contract may be entered into in any form provided all the essential requisites for its validity are present. Where the contract covered by statute of frauds, the contract of sale should be covered by the statute of fraud. The laws does not require that it be in writing subscribed by the party charged. Otherwise, the contract cannot be enforced by action, and where the applicable statute required that the contract of sale be in certain form for its validity, the required form must be observed in order the contract may be valid and enforceable. So if it is covered under the statute of frauds, it must be compliant with the provisions of the statutes of fraud. So under the statutes of fraud, the following contracts must be in writing, otherwise they cannot be enforced in court litigation. 1. Sale of personal property at a price not less than 500 pesos. Sale of real property or an interest in regardless of the price involved. And sale of property not to be performed within a year from the date thereof, regardless of the nature of the property and the price involved. You have to remember that this law is also old. The new civil code is already old, so there has to be some updates on this one. But these are the rules on the um, statute of frauds, and these contracts must be in writing. Okay. So where form is required in order that the contract may be valid. Okay, where the applicable statute requires that the contract of sale be inserted form for its validity, the required form must be observed in order that the contract may be both valid and enforceable. Where the form is required only for the convenience of the parties, then in order that the sale may be registered in the registry of deeds to make effective as against third persons the right acquired under such sale. So there is also this instance where the form is required for the convenience of the parties. Okay, so if that's the case, then you'll just have to comply with the form, okay, for by benefit of both parties. In this case, in order that the sale may be registered in the registry of deeds to make effective as against third persons the right acquired under such sale. So if the sale needs to be registered with the registry of deeds, it has to conform with the forms that's prescribed by and acceptable by the registry of deeds. So in the sale of real property or interest, okay, when made through an agent is void unless the agent's authority is in writing. It should have a special power of attorney stating that the person is an agent, okay, is the attorney in fact of the owner. For the sale of real property to be effective against third persons, the sale must be registered in the registry of deeds of the province or the city where the property is located. The sale must be in public instrument or document, so it must be notarized. The statute of frauds applicable only to executory contracts, and the statute of frauds applicable executory contracts, meaning it is going to be done the future date. Okay, it will be executed. What are the remedies of the vendor in sale of personal property payable in installment or the recto law? May be exercised in the following remedies. They elect fulfillment upon the vendee's failure to pay, cancel the sale if the vendee shall have failed to pay two or more installments, foreclose the chattel mortgage if one has been constituted, if the vendee shall have failed to pay two or more installments. So under the recto law, these are the following remedies for the seller, the vendor. One, we can elect the fulfillment upon the vendee's failure to pay. Two, cancel the sale if the vendee shall have failed to pay two or more installments. Or three, foreclose the chattel mortgage if one has been constituted if the vendee shall have failed to pay two or more installments. So una, pwede siyang intayin niya talagang i-fulfill ni vendee or ni buyer yung payment. Or two, pwede niyang ipa-cancel yung sale dahil nag-fail na siya to pay two or more installments. And three, pwede niyang ipa-foreclose yung property na naka-attach or naka-collateral if there is any, if the vendee shall have failed to pay two or more installments. So what are the nature of the remedies? Where the vendor asks the court to order the vendee to pay the remaining unpaid sum of the purchase price, the vendor thereby waives the other remedies. Okay, so kung ang pinili niya is number 1, where the vendor asks the court to order the vendee to pay the remaining unpaid sum of the purchase price, hindi niya na pwedeng i-cancel yung sale at hindi niya rin niya pwedeng ipa-foreclose yung any property in the chattel mortgage. Okay? Right of the vendor to recover unpaid balance purchase price, the remedy of specific performance. He may still recover from the purchaser the unpaid balance of price, if any, on the real and personal properties of the buyer not exempt by law from attachment and execution. So specific performance. Second would be cancellation. Can demand only the return of payments already made unless there is a stipulation about forfeiture. And foreclosure, you shall have no further action against the vendee for the recovery of any unpaid balance of the price. Kung ito naman ang option niya, i-foreclose yung property, if the amount of the foreclosure is not enough, he cannot recover whatever is the excess. Okay? The foreclosure is effected by selling the mortgaged personal property at public auction and applying the proceeds to the sale to the satisfaction of the claim secured by the mortgage. So, in one, he may still recover from the purchaser the unpaid balance of the price if any of the real and personal properties of the buyer not exempt by law from attachment and execution cannot satisfy that for specific performance. Meron pa rin siyang right. Sa remedy of cancellation, the latter can demand only the return of payments already made unless there is a stipulation about forfeiture. Okay, and then another is remedy of foreclosure. Kapag nagpa-foreclose, he shall have no further action against the vendee, yung buyer, for the recovery of any unpaid balance of the price and any agreement to the contrary is void. So, hindi siya pwedeng sabihin na kung hindi pa enough yung pinagbentahan ng na-mortgage na property, after na na-foreclose, maniningil pa siya, it is void. The foreclosure is effected by selling the mortgaged personal property at public auction and applying the proceeds to the sale of the satisfaction of the secured claim secured by the mortgage. So, dahil binenta mo na yung property na na-mortgage, then it will be used to cover the entire claim for the entire balance. Kung hindi siya enough, wala ka na further action that will allow you to recover the remaining amount. Okay? So, recovery of deficiency after foreclosure prohibited. As I've said earlier, hindi ka na pwedeng mangolekta beyond the amount of the foreclosed amount of the property. It prevents the mortgages from seizing the mortgage property, buying it and foreclosure sale for a low price, and then bringing suit against the mortgagor for a deficiency judgment. Doesn't work that way. Okay? So, how about lease of personal property with option to buy? So, ito mga rent to own. Diba? This is uso din ito ngayon, rent to own. On the part of the lessee who takes possession or enjoyment of the property leased are really sales of personal property payable in installments. The evident purpose is to prevent vendors from resorting to this form of contract, which usually is in reality a contract of sale of personal property payable in installments in contravention of the provisions of Article 1484. Okay. So what about if there's stipulation authorizing forfeiture of installments or rents paid? The parties may actually stipulate that the installments or rents paid are not to be returned. Such a stipulation is valid insofar as the same may not be unconscionable under the circumstances. Otherwise, the court has the power to order the return of a portion of the total amount paid in installments or rents. So, in relation to this, especially for rent to own, di ba, kung mga 10 years ka nung nagbabayad and the rent to own contract was like 15 years, and then you suddenly cannot afford to pay the entire amount, here, if there is a provision that any and all payments that you have paid so far can no longer be returned and is already forfeited, and you will also be subjected to be evicted from the property if you're occupying the property because you can no longer pay the agreed amount to be paid every month, the court may intervene as the power to order the return of a portion of the total amount paid insofar as it is just and equitable, okay, as part in the paid in the installments or the rents. So, what is capacity to buy and sell? Okay, so a person who may enter into a contract of sale should have the capacity. So, a general rule, all persons, whether natural or juridical, who can bind themselves by contract have also legal capacity to buy and sell. The exception is when the law determines that party suffers from either absolute or relative incapacity. What is absolute or relative capacity? When you say absolute, it is in the case of the person who cannot bind themselves, and relative incapacity where it exists only with reference to certain persons or a certain class of property. Okay? Like you cannot sell to your husband or your wife. Okay? You cannot donate to your husband or your wife. Capacity relative to your person. You can contract a sale um, to another person but not to specific person. So that's relative incapacity in reference to a certain person lang. So, liability for necessaries of minor or other persons without capacity to act. So, necessaries are those which are needed for sustenance, dwelling, clothing, and medical attendance in keeping with financial capacity of the family of the incapacitated person. So generally, the contracts entered into by a minor and other incapacitated persons are voidable. Yun yung sinasabi natin. When you are having your obligations and contracts, okay? What are the um, defective contracts? No, one of them would be voidable. So generally, contracts entered into by a minor and other incapacitated persons are voidable. Okay, however, where necessaries are sold and delivered to him without intervention of the parent or guardian, he must pay a reasonable price therefore. The contract is valid, but the minor has the right to recover any excess above a reasonable value paid by him. Kung sakaling nag-overpay siya, kasi nga, he's indeed not capable of giving consent. But the contract is going to be valid. So it's voidable. Okay. So, sale by minors. Paano naman kung si minor ang nagbenta? When the minors pretend that they are now in adult age, while in fact they are not, yeah, the sale is valid. They cannot be permitted to excuse themselves from compliance with the obligations assumed by them or to seek their annulment. Sila naman yung nagsabi na they are already of age to enter into the contract. Relative incapacity, as I've mentioned earlier, husband and wife, they are prohibited by Article 1490 from selling property to each other. So, relative yan kasi any husband or wife of another can sell to any other person except to the husband or to the wife. Okay? They are also prohibited from making donations to each other during the marriage except moderate gifts on the occasion of any family rejoicing. If there has been a separation of property agreed upon in the marriage settlements, or when there has been judicial separation of property decreed between them by the court, the sales between them are allowed. So this is the exception. Okay? When there is judicial separation of property decreed between them by the court, or if there is a separation of property agreed upon in the marriage settlements, they can sell between each other. But absent those conditions, they cannot sell towards each other, the husband and the wife. Okay? Pag may asawa ka na, ka pwedeng magbenta sa kanya. Okay? Reason for prohibition under Article 1490, the possibility that the husband will induce his wife to engage in ruinous operations. The prohibition is primarily for the protection of third person who, relying upon supposed property of either spouse, enters into a contract with either of them, only to find out that the property relied upon was transferred to the other spouse. Madali nilang manipulate kasi nga mag-asawa sila. So it's prohibited. Okay? So are persons permitted to question sale? The heirs of either spouse, as well as the creditors at the time of the transfer, can attack the validity of the sale, but not creditors who became such only after the transaction. Okay? Siyempre, wala pa silang right. Noon. The government can also question, okay, the sale. Incapacity by reason of relation to property, the persons who, because of their position and relation with the persons under their charge or property under their control, are prohibited from acquiring said property under their control. There's also the guardians, agents, executors, administrators, public officers and employees, judicial officers and employees and lawyers, and others specially disqualified by law. Di nila pwedeng bilhin yung property ng guardian nila. Okay? Or yung agents, bilhin nila yung property ng principal nila. Okay? Reason for prohibition, it is to prevent frauds on the part of the persons enumerated therein and minimize the temptations to exertion of undue and improper influence. Kasi nga, sila ang nagtitend over those properties of or the executors, administrators, guardians for their wards, agents to their principals. Okay? So parang walang or maiwasan yung fraud that is prohibited as well. Other persons especially disqualified, who are them? Aliens who are disqualified to purchase private agricultural lands, unpaid seller having a right of lien or having stopped the goods in transit, the officer conducting an execution sale of property to enforce a court judgment rendered against the owner. Ito, officer lang sinaman, di ba? Kung ikaw officer, tapos ikaw din yung bibili, di ba? Privy ka sa transaction, mabilis ka, di ba? So, hindi pwede. Prohibition extends to sale in legal redemption. So, compromise, okay? It's a contract whereby the parties, by reciprocal concessions, avoid a litigation or put an end to one already commenced. It is the amicable settlement of a controversy. That's what you call compromise. By renunciation, a creditor gratuitously abandons his right against his creditor. The other terms used by the law are condonation and remission. Yan, yung mga sinabi nila, renunciation. Oops. You guys can still see my screen?
Yes, sir.
Yes, sir.
Yes. Oops. Okay. I think that's the last bit for this topic. Any questions so far? Okay, so that's it for auction sale and other related topics to sale. Are there any questions regarding the discussion?